SJC-10593, Commonwealth versus Keown.
Good afternoon, Ms. Bulgin.
Good afternoon, Your Honor.
Is it Bulgin or Bulgin?
Bulgin.
Bulgin. Okay,
Thank you.
thank you.
How do you pronounce your client's last name?
Cowan.
Cowan, thank you.
Cowan. Yes. Good afternoon, Your Honors. May it please the Court. Claudia Bulgin for James Cowan. I'd like to begin with the issue of minimization protocols for digital searches. This Court should require minimization protocols for two main reasons. The first one is that warrants authorizing exploratory rummaging searches of every file in a computer hard drive are general warrants prohibited by Article 14 and the Fourth Amendment. And the second reason is that judges and not police or civilian forensic examiners should be the decision makers as to particularity for digital searches.
Have you had a chance to read the latest two cases that came down on that
I
issue?
have, thank you.
And how does that fit into what you're asking us?
Well, in Molina and to a lesser extent in Martinez, this court indicated a willingness to consider requiring search protocols for digital searches because of the privacy concern that was expressed in Molina and Martinez. The privacy concern is that continuing to treat a hard drive or a cell phone or a similar digital device as simply a place, as a box to be searched however the police feel like it, is such an invasion of privacy that our society is not okay with that. And in order to swing the balance away from the governmental interest in solving crime, more over to the privacy interests of individuals in these indispensable digital devices, is to require ex ante, before the fact, minimization protocols so that a judge is the one who can decide, well, is the Commonwealth doing the best they can to minimize the privacy intrusion in the search that they're about to do of the massive amount of files that they have?
Other than the Ninth Circuit case, have concurrence? What is the where's the state of the case law about requiring ex ante restrictions, or does everybody read Professor Kerr's articles and avoid it?
Well, Professor Kerr's articles are countered by Professor Ohm's and Professor Gershowitz's articles, but with regard to the state of the law, the closest that a court has come who is, let me stop there. There are federal magistrates in Kansas and Nevada, in District of Columbia, that have been very vocal and concerned about this issue and have written opinions to the effect requiring protocols.
Right, which you cite one I read, and I can't remember where that was.
Indeed, and CDT, which is the case that Your Honor had cited in the Molina case, came pretty close. Originally, that opinion required the protocols, and then that got withdrawn, and the en-banc opinion ended up with that as a strong concurrence suggestion. But in terms of requiring protocols, at the moment it is at the federal magistrate judge level. In terms of saying that protocols are a good idea, maybe not requiring them, but approving them, the Vermont Supreme Court, in geography as well as stature, is the closest court to this one, who has extensively reviewed ex ante minimization search protocols and has approved them as a constitutional use of the judicial power in order to make certain searches of digital devices are particular.
Is this the right case to make that decision when we're looking at a search before iPhones were out back in 2004, and that what we take for granted now with the internet, 2006, what we take for granted now with the internet wasn't what the world was like then?
Yes, Your Honor. The 2004, 2005, 2006 timeframe was a time when the internet was used by over 70% of the populace. Maybe cell phones weren't as popular then, but certainly the internet was. And with regard to personal computing, it was very popular at that point as well. But take that aside, the issue of a laptop and the issue of a cell phone are the same. Why? Because the reason digital is different, the reason that Riley versus California came out the way it did, is the three main issues with digital as opposed to physical, which is the enormous nature of digital storage. In this case, the forensic examiner examined 397,000 files. So with regard to today, certainly that number has just expanded, but that's still an enormous amount of
But
information.
Professor Casey in the amicus brief makes the point that that's just not how you do searches. It would be impossible to do searches that way, and a protocol would just mean that certain things like deleted files would never show up.
What Professor Casey advocates in his amicus brief is, don't fence me in. Trust me, I want the ability to look at every single file in this computer. Whether or not I actually end up exercising it, I want the ability to do that. And that is the problem. That is the general warrant nature of the search in digital devices that we are dealing with here. He says up front, oh, well, a person could never read that many files. No question. But they want the ability to pick and choose at their discretion through these files. And the problem with that is, as a society, are we okay with that level of privacy intrusion into our very sensitive digital devices that we all hold dear and that each one of us knows if that
What
was
about the search terms that were used in this case by the examiner? Did that limit the government's ability to rifle through the computer?
Had the search terms been upfront specified
In the warrant
in the
application?
warrant, that is really the issue. We are saying that this warrant was bad at issuance with regard to
But
the
in
search that
practice,
was done.
what McSweeney did was go through the search terms, correct?
Winrow was the actual examiner that examined the Sony Vaio, which is the computer at issue here. What he did is he took search terms that had been generated a year prior, which certainly would have been available at the time that the warrant application in this case had been prepared to give to the judge. But be that as it may, that wasn't done. He took those search terms and then he added some of his own. The prosecutor added search terms of, that they sort of ad hoc came up with. So it wasn't just the search terms that those were searched, that the civilian forensic examiner had, ability to put the search terms in, as did the prosecutor. In addition, that wasn't the extent of the search. The examiner testified that he searched perhaps 10,000 image files and zip files manually. Then when he added search terms, those situations came up that weren't part of the original keywords. But the actual search that was done here is not my main argument. That's a secondary argument, that the search wasn't reasonable, that the search wasn't particular. But the main argument is, at issuance, this warrant was bad. And as a general warrant, any evidence that was found should be suppressed. That's Commonwealth versus Lett.
What should they have done here?
What they should have done is what you should require going forward, which is, at the time the warrant is applied for, to apprise the judge of how the Commonwealth intends to not intrude unnecessarily on the privacy of the person whose device is put forth. It's a search protocol, and that can consist of a variety of different things. It can certainly consist of keywords. It can certainly consist of a firewall sort of arrangement. That was part of the Vermont Supreme Court's case, and of CDT as well. It can consist of an explanation of what forensic search tools will be employed, and how those tools work, and how those tools differentiate between files that could be relevant and files that could not be. It could also be a restriction on the type of files or the type of apps that will be searched, depending upon the probable cause to seize certain items that are in the warrant. What the Commonwealth wants to come away with here is no judicial oversight of how the search is done. And that falls too far on the spectrum of not protecting citizens' privacy rights in their private, sensitive digital devices that hold their privacies of life. Just like in colonial times, it was the house and the writs of assistance that resulted in Article 14 being written by John Adams allowed customs officials of the Crown to search from cellar to the attic, anywhere they wanted, breaking open anything they wanted, to rifle through anything they wanted. And in colonial times, it was the house that was most sacred.
So would you have any problem with a sort of category of items that are being searched for, and then are you suggesting that the expert or the Commonwealth needs to come back if none of those works and says, we want to add these terms? Is that what you anticipate?
The answer to that question is I wouldn't have a problem with that. But keyword searching, as Egan Casey says in his brief, is only a tiny part of how forensic evidence gets found on these hard drives. Apparently, tools are being developed all the time to continue to refine the way forensic evidence is examined, because, as Justice Lowy pointed out, with files, hard drive sizes getting bigger, there's no conceivable way that a forensic examiner in a year or 2 years could actually look through every file. So the tools that are used are critical for the judge to understand. How do these tools protect against finding intermingled documents or files or information that there is no probable cause to look at? So there's a variety of things a judge can do.
So if in your world, they identify a set of search terms, they implement that, and let's just say let's say life insurance is a search term, and then during the course of that examination, they develop documents that indicate that maybe they should use annuity. They have to come back for another search warrant?
The answer to that question is yes, but that isn't a big problem, because when a forensic examiner gets into the hard drive and finds, well, there's other things that I need to do, or what my original idea here wasn't, didn't work out, yeah, they can come back. And that isn't an enormous intrusion on either the judge's time or on the forensic examiner's time if weighed and balanced against the privacy interests that our society deems very precious in these digital devices that hold our entire lives.
Well, let's imagine, we won't go back to colonial days. Let's just go back to 1980. If they had done a search of your client's home, let's assume he had many file cabinets and had done something akin to what is an Addendum A, would you say that that is an unreasonably broad scope of the search?
That would be totally fine. The problem we're running into here is the analogy from the digital world to the physical world doesn't work to support any sort of privacy interest in the digital world. So the cases that the Commonwealth cites and the cases that might be in some of the law review articles that say, oh no, particularity doesn't deal with how the search is done. Those are cases in the physical world. In the digital world, it's just different, not only because of the scope, the enormity of the files, the sensitivity of the files, but also the intermingling of the files. Your Honor makes a very good point in the question earlier that it's not just files. Files aren't files in the digital realm. They're bits and pieces of information scattered all over the hard drive that may, when pieced together, look like a file to you and I when we simply fire up our Windows computer and see the files. So they're not at all the same thing, and the analogy just breaks down.
But if it were paper files, and I don't mean to appear to be too much of a dinosaur, just a minor type of dinosaur, if you went in and you found a file cabinet, you wouldn't necessarily expect that it would be filed under the category of, poisons to kill my wife. They could be anywhere, and you wouldn't limit them to say you can only look into the poisons file. You would imagine they would put it somewhere else. In a computer file, why should you assume that the person is going to keep it in a poisons file as opposed to a file of great songs of the 60s and then hide it there?
Well, two responses to that. First of all, not every computer user is so sophisticated that they know how to do that. So if indeed you have a case where there is some evidence that this computer user is a computer programmer or has IT background, perhaps then the search protocol might be a little bit more broad. But that would be an outlier case. The normal person like, you or me would probably not know how to do that. And so
Put the file in a different file?
or somehow disguise it. I mean, there are apparently software programs that will allow you to disguise files themselves that might be contraband. For example, child pornography is something else. But so with respect to that, in certain cases, that might be a consideration as to what protocol is useful.
So the police are going to have to go to the judge and guess how sophisticated the defendant is? And then if they don't find anything the first time around, your argument would be you didn't find anything.
No, my argument would be if they didn't find anything the first time around because they suspected that their searches, or their protocols that they had originally filed with the judge and gotten approved were the problem, then at that point they could come back and say, okay, I want to search, I, the forensic examiner, want to search this way. And so the issue is that's not too big a price to pay for privacy in our digital devices.
I guess I might have to prove I am a complete dinosaur, but when you talk about particularity, not necessarily dealing with how the search is done, putting aside subparagraph F of the affidavit, there are limitations as to the nature of the, quote, files, end quote, having to do with health, having to do with financial records. So why isn't that a limitation that satisfies what we always think of as particularity?
Because that warrant requested access to every file on the hard drive in order to find those particular things that were specified. It's the access to every file on the hard drive, if we want to, that is the problem, and that makes this warrant at issuance a general warrant.
Professor Casey says you could have the, I can't remember if this is his example, you could have the suicide note in the file on games.
No question, but Professor Casey also says, well, look at these whiz-bang new software treatments that we're developing right this very minute that helps us deal with that problem. And so keywords maybe were a dinosaur of 10 years ago. Maybe now the search protocols that the Commonwealth would come forward with. It's not the judge that has to come forward with these protocols. The Commonwealth, with its forensic expert, comes forth and says, gee, look at this great new software thing that's going to be able to find these files in such a way that we'll get our evidence, but we don't have to have a human look at, 99.9% of the files in this computer. That's the sort of search protocol that I'm advocating for. Make the Commonwealth show the judge who's issuing the warrant and who's responsible for not issuing a general warrant that they are doing everything possible to minimize the intrusion on privacy. They don't want to do that because they want the judges to trust them. Oh yeah, we're going to make this search so that we're not going to invade this person's privacy. But it's not the judge's responsibility to trust the police on this issue. It's the judge who has to ensure this warrant is particular, or else it's a general warrant and it's prohibited by our Article 14 and by the Fourth Amendment.
I know your time is up, but I know that your secondary argument is that the search as it was conducted was unreasonable. Can you, in a minute, tell us why the search as done here was an unreasonably broad search beyond the appropriate scope of the warrant?
Well, I need to back up to the fact that there was no probable cause to issue the warrant in the first place.
I know that. Put that aside. I'm just
Put that
focusing on
aside.
just focusing on the issue of the reasonableness of the conduct of the warrant in 1 minute.
First of all, there was the error in paragraph F, that what resulted in the error was, yes, there were categories of files that were being searched for based on subject matter. But the way that that internet paragraph F read is that anything that he ever searched for anytime, no matter what it was subject to search and seizure of that. And so that is the problem with the warrant itself. The manner of the execution of the warrant is that they were sort of ad hocing these keywords. There was no oversight. There was, these keywords were sort of being added and searched for sort of in an ad hoc way. And it's, again, the rummaging, that's the problem here. Rummaging searches are a problem. And so the whole way this was conducted with no sort of overall strategy that was vetted by a judge is the difficulty.
Okay, thank you.
Thank you.
Mr. Charles, good afternoon.
Good afternoon, Mr. Chief Justice, Associate Justices. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. This issue of ex-ante restrictions has somewhat hijacked this case, but there are some other issues that were raised in the brief that I would like to address first, with the Court's permission, that specifically being this idea that there wasn't probable cause or a nexus in the affidavit. Amici and my sister both cite this Court's recent decision in White, which came down a couple weeks before the Commonwealth filed its brief, and suggest that under White, this warrant is blatantly insufficient. And the Commonwealth would just say that that couldn't be farther from the truth. This Court's decision in White, while valid, was a narrow holding. It essentially said that where you have no evidence that a digital device was used in a crime, and where you have nothing more essentially than the fact that a crime was committed and that based on your training and experience, people use digital devices in crimes, that is not sufficient for probable cause. In White, the officers had no evidence of a cell phone's involvement in the robbery. They also had no particularized evidence that they expected to find on that device. And neither of those things are true here. I would submit that in this case, if you look at this rather detailed affidavit, there was a plethora of information beyond.
What's the evidence that this computer was used in this crime?
Well, I would just preface my response by saying there's no requirement that there be direct evidence that this particular computer was used. The reason that there was a belief that this computer was used was we had a very idiosyncratic form of murder by a layperson who had no medical training, and this individual would have had to research how to do this. He would have had to learn, what substance do I need to use? What dosage do I need to administer the substance in to this victim that it will simultaneously be enough to kill her, but also not be detected? How do I disguise this substance and in what? So these are all things that this defendant could not possibly have known as a layperson.
Have you found any cases to that effect around the country or anywhere else?
Not anywhere else, but I would submit we don't really have to go past White. In footnote 9 of White, this Court cites favorably to both Anthony and to McDermott, which the Commonwealth cites in its brief. And essentially that is for the proposition that if you have evidence that a crime is committed, and you have evidence that there is particularized evidence of crime that you're looking for, that plus training and experience can get you to a particular device. So just to summarize briefly, and I can elaborate, but in paragraphs 3 and 4, there was evidence that the victim definitively died from ethylene glycol poisoning, that it can result from small amounts ingested over time, and that the ingestion causes a variety of problems in the body.
The training and experience of the police officer, that's what you just That's what you're.
No, this is evidence, this is not based on training and experience. This is, the ME concluded that it was death by ethylene glycol
No,
poisoning.
I read the affidavit. I get that. The question I've got is this notion that if you have a crime that entails some type of research that gives rise to probable cause to search a computer, do you have any support for that?
We can find a nexus to a device based on the type of crime where we would expect people to keep evidence of that crime. I don't have a case for you in Massachusetts that has dealt with this specific issue. But if you look at the affidavit in this case, we have a defendant who worked with computers, who was working in web design. He worked remotely, on his laptop. He wasn't working in an office.
Okay.
He worked remotely from Boston on this laptop.
Well, he wasn't working, was one problem.
That's true, but he
But
was.
we don't know what the heck he was doing, because he was having other people do the
Well,
website.
to correct you, he was working initially. He was not fired until July. They moved to Boston at the beginning of 2004. So initially, he was still working for the Learning Exchange, and this poisoning commenced in late May and early June. So he's working remotely on this computer. There's evidence. If you look at paragraph 22, this defendant, shortly after the victim's death, starts telling individuals that, well, I heard of this condition. It's methylmalonic acidemia that can cause propionic acid to form in the body and look like EG poisoning. The defendant could not possibly have known that. He clearly researched these things. These are specific medical things that the defendant looked up in order to effectuate this crime and try to cover it up. He then takes this computer with him to Missouri when he flees the Commonwealth. It certainly was reasonable to conclude that this defendant had to look up a way to commit this crime, to do it in a very surreptitious way that he would not be identified. He made this comment to Dr. Rankins after the victim died. So if this was deemed an accidental death, that's the end of the investigation, right? No, I mean, he had tried to poison her in a way that it would not show up. Even when he first dropped her off at the hospital, has she ingested anything, any suspicion that she'd been poisoned? Oh, no. It's only after this EG diagnosis is made by the doctors at the hospital that the defendant starts fabricating these stories about how she might have ingested it. So he was clearly trying to poison her over a prolonged period of time. She had these symptoms in an escalating variety from beginning of June through her death in early September, numerous hospital admissions, presenting with symptoms consistent with this sort of EG poisoning. He had to look up how to do this. No one knows, just unless you're, I suppose, a trained medical expert or someone who works with these sort of poisons, you don't know how to do this. And it is not unreasonable to conclude that this defendant who worked with computers, who had used computers in the context of his job to commit unlawful acts previously, who was working from home on this laptop, not in an office, in this time frame in 2004 where mobile hotspots are not a prevalent thing, the cloud is not a prevalent thing, iPhones don't exist, apps don't exist, it is completely reasonable to conclude that this defendant researched this crime on his personal laptop computer.
But you say it doesn't matter if it was his personal laptop computer, because if it were 1960, you could go both to check if there was something taken out at the Woburn Public Library or at the Winchester Public Library. It doesn't matter which one, but in this particular case, we have to deal with that the search has to be particular and there has to be probable cause. Your position is that there doesn't have to be probable cause to this particular personal computer.
There has to be probable cause that there is evidence of a crime and that it is reasonably maybe expected to be located, I think is the language this court used in Dorellis, on a particular device.
On this one that was searched.
Or as this court's other cases, I would say even most recently Molina have shown, it doesn't necessarily even have to be that it was this. If the defendant had multiple computers.
Well, in this case, it does have to be this computer, doesn't it?
I think if it was on,
I mean, the
what I
search
mean to
warrant
say
was
is,
for this one.
if we had the same information in here and we had seized not only his Sony Vaio, but let's say 2 other towers with hard drives on them that we thought might have contained the same evidence because they were the defendant's computers. We could search all of those computers. And this court found that that was true in Molina most recently, where we know that it's likely that a computer was used, but we don't know which. We can seize them all. So while we seized this Sony Vaio, if he had also had 4 other laptops in his possession, we could have seized them all and searched them all, I would submit, because we know that he had to research this and he had to do it on a device that was in his possession, is all the Commonwealth is saying. So here, I think this case is clearly distinguishable from White, and there was an ample nexus based on all of the circumstances in the warrant to conclude that they could search this computer. And I would also say that while I'm confident that this search withstands the scrutiny of Dorellis and White and the other cases that have come down in this past year, I do think this is a circumstance where, akin to this court's recognition in Beauchamp, which was a 1997 decision, that there may be circumstances where a defendant cannot get the benefit of developments in the law where a case is pending for a long time on direct appeal. If you look at Riley, if you look at this court's decision in Augustine and other similar recent decisions, it is not just that the law has changed. This change has been in direct response to not only the advancements in technology, but the advancements and the proliferation of our interaction with technology. I think Riley acknowledged that 3/4 of smartphone users now admit to being within 5 to 10 feet of their phone at all hours of the day.
That far?
That's fair. And so I would just say here, where we're talking about a search that happened, excuse me, sorry, in 2004, a search that happened in 2000.
Well, it happened in 2006.
The searches on the computer happened in 2004. The search was executed on the, I'm sorry. The defendant searched these things on the computer in 2004.
Oh, right, okay.
The search of the computer, that is correct, happened in 2006 is what I meant to say. So, as this court, again, acknowledged most recently in Molina, in hearkening back to McDermott, this court said, you know, technology has advanced a lot in the last decade, and that's true. And so we're not just talking about cases that have changed the law. We're talking about cases that have changed the law in direct response to technological advancements and to our interaction with technology. Certainly the technological landscape is vastly different, and our action with it is vastly different today. And so to apply that to a search that happened way back in 2006, that predated this court's decision in McDermott, which essentially said everything the police did in this case was right.
Yeah, but, I mean, fair, but McDermott, it's now 2017, so.
But again, I would say in White, this court cited favorably to McDermott in finding that there was an actual.
I get your point. I mean, your point basically is you got to look at 2006, not 2017.
I'm saying I don't think you have to get there. I think we get there under your current law, but I think it's unfair to apply this recently developed law to a search that happened in a completely different technological time. Moving over to this issue of ex ante restrictions, I think the Commonwealth has two separate points. The first being, which I'll touch on briefly, is that judges do not have the authority at the outset when they are approving a warrant to impose these sorts of stringent ex ante restrictions.
Why don't we have the authority?
Because all the Fourth Amendment is concerned about, and particularly with regards to particularity, is there probable cause to believe a crime has been committed, and where can we expect the evidence of that crime to be found? Judges have not been found to have authority to dictate how officers go about executing a warrant.
Did anybody tell the magistrate judges that?
Well, I will concede that there are magistrate judges at the district court level that are doing this thing, but I would just note for your honors that, first of all, no appellate court, state or federal, has required, as Amici and my sister suggest this court should do, that these protocols be mandatory. All we have is comprehensive drug testing in the Ninth Circuit in a concurring opinion suggesting that this is useful guidance, and Vermont Supreme Court in a split decision saying these are permissible. The First, Second, Third, Fifth, Sixth, Seventh, and 10th Circuits have all questioned the utility of these restrictions
It's
explicitly.
different from saying we don't have the authority, Mr. Charles.
Well, I understand, Your Honor, and again, I'm making two separate arguments. The first being there is no authority, and to that I would, just to elaborate, I would.
Before you leave that, even if it's an attorney's laptop where there will be attorney-client communications?
I'm talking about this specific idea of dictating how a search occurs just because we're talking about a digital device. Preventive medicine is a completely separate question. We're talking about a situation where we're in a post-indictment context where we know that there is an attorney retained before this device was seized. We know that there are going to be privileged communications. And it's the separate constitutional concern about privileged information that drove the taint team procedure in that case. That is completely devoid from this more general argument that just because we're talking about searches of computers and cell phones, which, by the way, I would note, are totally different, The file structure on a cell phone is extremely rigid, and there's very little mobility in terms of how you can label things and where they'll be. It's essentially, as Professor Casey said, an archaeological excavation when you go to examine a computer. People can store things anywhere, they can name them anything, they can delete them, at which point they have no more metadata, and they're in this unallocated space that can't readily be searched by a variety of methods that might otherwise work if they were
Say
still on
that
the
all
computer.
that's true. What do you do then to make sure that you don't have a general warrant when a device is seized? What do you do taking the particularity requirement and now imposing that in a situation where we're concerned about how the search is done?
I think this court's current rubric is sufficient. In Durellis, this court essentially established sort of a heightened particularity requirement in terms of how specific we want law enforcement officials to be in describing what they want to look for, whether that be, if feasible, temporal restrictions, category restrictions, which again I think are more suited to cell phones than than laptops or other digital devices. And then also, like as we had in this case, categories of evidence, files relating to poisoning, files relating to financial conditions, files relating to life insurance. So this heightened particularity requirement, essentially the Commonwealth would submit, has covered these particularity and privacy concerns on the front end, and the defendants have made no demonstration that the tried and true method of an adversarial ex post motion to suppress, where witnesses can be presented and cross-examined, where a judge will have a full record rather than making these predictive determinations about what might be reasonable beforehand, is insufficient. Defendants can't just come in here and scream the sky is falling without any demonstrated evidence that there is this pervasive problem of indiscriminate searching. I would suggest, as this court acknowledged in Molina, the law enforcement was very circumscribed in their search in that case. I would submit that this record shows a very circumscribed search by Andy Winrow. He essentially testified that he plugged these
The point is,
search...
he didn't have to. He could have searched every single file.
But we have a mechanism to assess whether people act reasonably in the execution of a search. If Examiner Winrow had gone on the stand at the motion to suppress and said, well, you know, I added the term child pornography because I thought maybe this guy had kiddie porn on his computer, that would have been an unreasonable search term. That would not have been within the parameters of the warrant. It would have been suppressed.
Well,
But his testimony was that he
Somebody
conducted a
is
very
irrelevant.
narrow, reasonable search. He examined, I think, 325 files out of 400,000. And the majority of the hits that he testified he got, he was not viewing files. He was not putting eyes on files. He was looking at the search term that was responsive, surrounded by 5 to 10 characters
so
on either
wrong with
side.
the idea that the warrant application should say, the way that we're going to go about this is using N case, and we're going to do X, Y, and Z. What's so wrong about that?
Because you can't know what is going to be necessary until
Heck.
we're going to devolve into the situation like Logi, which Professor Kerr cites in his articles, where essentially the magistrate or the judge is quarterbacking the search and dictating 5, 6, 10, 20 different times what the next step can be. It's going to be unduly burdensome to the court system, to law enforcement, to the defendant's rights to a speedy trial. It's not necessary. I think we're trying to find a solution to a problem that has not been demonstrated to exist. I think that this record is ample evidence that there was that reasonable searches do occur, and absent evidence that there's this rampant abuse of power that these examiners, who, by the way, have an inordinate amount of devices to review. I believe the AG's office, which has 7 employees in their digital evidence lab, reviewed something like 1,600 digital devices last year. To think that they could do that while at the same time conducting these quote-unquote rummaging, indiscriminate, exhaustive searches of devices that now can have upwards of a terabyte of information, it's not realistic. There's no demonstrated evidence that this is happening. The defendants are saying, let's assume the worst-case scenario, absent any concrete evidence that that's actually a problem, and why don't you grant me some relief based on this hypothetical situation that hasn't been demonstrated to exist? Whereas here we have a record that clearly demonstrates that the officers executed the warrant in a reasonable way. They only ultimately conducted an in-depth review of approximately 325 files. I would invite this court to requisition the evidence and look at the report. Most of the stuff that even was responsive is not, a journal entry that's legible and incriminating. It's this diffuse amalgam of data that's carved out of unallocated space. It's fragments. And that's another problem we have with this idea of temporal restrictions and telling you how we're going to do the search. Criminals, they don't leave incriminating evidence just laying around in plain view. They delete it. They hide it. And search terms are not necessarily going to find those things. We need to have the ability to adapt to where things may be on a computer. And it's just, absent some demonstrated problem with the way these searches are happening, or absent a conclusion that this heightened Dorellis particularity requirement, coupled with an ex post motion, adversarial motion to suppress to assess reasonableness, is insufficient. We shouldn't be further clogging up these searches by requiring that there be this constant back and forth where law enforcement repeatedly has to come back and get approval every time they want to add a search term, use a different search tool. It's just sort of, it's an exhaustive remedy to a problem that doesn't exist.
So would it be inappropriate for us to say that in terms of the reasonableness of a search done post hoc, we would expect that there would be a reasonable protocol established before the search began?
I certainly think it's reasonable for this court to expect, as it's suggested in Dorellis, that efforts be taken to conduct the search in the narrowest way possible. I don't know that I would go so far as to saying it would be appropriate to require a written protocol be drafted.
I didn't say written, I said a reasonable protocol, but
But I mean, certainly, I think if you asked the Attorney General's office, as you sort of did in Molina, they would tell you that a protocol, for lack of a better term, or a rubric for how they're going to go about looking at a device, they do that in every case. They don't just start randomly applying methods. They assess the file structure of the device, they review the warrant, they review the relevant documents pertaining to the investigation, they come up with a plan of attack for how they're going to be able to find the most responsive documents that fall within the rubric of the search parameters of the warrant in the fastest way possible, so they can get that evidence.
Professor Casey says to do it any other way makes no sense.
I'm sorry?
Professor Casey says to do it any other way makes no sense.
And on that limited point, Professor Casey and I agree, although there are certainly several other areas where we're not on the same page. I see my time is up. If there are any other issues in the brief that Your Honors would like me to address, I'm happy to.
One fast question.
Yes.
For one of probably the only person in this room who has not seen the movie The Usual Suspects.
That's not true.
Was there any, I gather there was no reference made during the course of the trial to that movie?
No, and to give the court some context, there was, during the second day of the motion in limine, there was extensive argument about this idea of Kaiser Sose.
Did the Commonwealth at any time seek to put that in because it sort of reflected, I mean, as some indication of state of mind?
Candidly, Your Honor, yes, they did. And that was, that was our argument on the second day of the motion in limine. This defendant chose, I mean, we can't view this in a vacuum, right? The defendant chose to use the username Kaiser Sose. We didn't pick it for him. We didn't create this evidence. So the Commonwealth's position was, yes, this is relevant evidence to his state of mind and his intent. The judge limited that. The judge said, no, I don't want that coming in. I don't want any mention of it. We're only going to use it for purposes of use of control of this computer, which was, I think my brief amply demonstrates, a key issue in the trial, both through opening the presentation of evidence and closing. Like, we can't know who was at this computer. This was concrete evidence that the defendant was the individual doing these searches on this computer. And all that came in was that Kaiser Sose was a username relevant to the use of control. The jury was instructed on 3 separate occasions that under no circumstances could they consider it for anything other than that. The juror who had a question was instructed that he couldn't tell the other jurors who Kaiser Sose was. I mean, the judge took every possible step to limit the exposure of this evidence. And while I would admit that Kaiser Sose in and of itself is prejudicial to some extent, it was certainly probative in this case, and the defendant has to live with the name that he chose, and he made the decision to argue that you can't prove I was the guy doing these searches. And here we have, you know, the Kaiser Sose username used to conduct searches before the victim's death, and then we have it being used again by the defendant as a name of a wireless network after she's dead, and to conduct searches on this Vio computer when he's in Kansas City, again after her death. So that was the connecting link that showed, you know what, this defendant's likely the guy that was doing the searches. And I think the cases the Commonwealth cites, Carey, O'Brien, we allow prejudicial information in all the time. I believe in Carey it was strangulation videos came in because they were consistent with the modus operandi of the killing. So, but as long as it's probative and it's not substantially outweighed by the prejudicial effect, which I would say here it's not, because no substantive evidence about who Kaiser Sose was came in, and we had repeated limiting instructions, I don't think there's any error, let alone any prejudice here.
Okay, thank you.
Thank you very much.